is now starting. All attendees are in listen-only mode.
Welcome to our webinar, discussing Directors' Responsibilities. I'm Sandra Mundy, a restructuring and insolvency partner with James Cooper Creston, and I'm joined by my colleague Sue Staunton, an audit assurance and business advisory partner. So I'm going to speak about the possible implications for directors on the failure of an entity, but I wonder if you might start by giving us more details on the day-to-day responsibilities and what directors should be focusing on.
Thanks, Sandra. Yes, hello everybody. Well, I think one of the problems is that people aren't always familiar with actually what is a director or who is a director. Very often people find themselves promoted to director status, and it's a way of giving somebody sort of accreditation they've moved on in terms of their career. Sometimes it's used as a title denoting leadership, so somebody who's head of a team, for example. But in reality, the title director actually has some very firm statutory definitions.
So there's more directors, more people called by the term director than necessarily are registered at Companies House, is that right?
Well, yes, I think what's probably sensible is if we go through and think about what the different types of directors are. So directors per se actually have very strict statutory and common law duties and responsibilities. A statutory director is somebody whose name is filed at Companies House in relation to a company, and they're a director of that company. It's worth noting that trustees of charities are also directors and therefore have those responsibilities. And I think sometimes if people are called trustees, certainly I've met people who are, they haven't realised that they actually also are statutory directors and have those responsibilities. And
probably gone to an organisation to do something good for the community.
Absolutely, absolutely, and that's a real risk. I think you're just trying to do good, and actually you can cause yourself personally lots of issues as a result. If you're not filed at Companies House as a director, you can still fall under the catch-all of the obligations and responsibilities simply by being called a director, and you're being held out in the marketplace, generally as a director, and that's called being a de facto director.
So, for example, if your business card said sales director, but you weren't sat on the board, but it was just a title, could you be a de facto director?
Yes, you could, because to somebody outside your organisation, they would expect somebody called a director to have those responsibilities and obligations, and have capacity to bind the company in the way that a statutory director could do. So it's something to be aware of. And then the other type of director that people aren't always familiar with is a definition that's given in the Insolvency Act, actually, which you'll be familiar with, Sandra. Somebody called a shadow director, and that's somebody in accordance with whose instructions a company is accustomed to act, but is not necessarily formally appointed, or indeed are called a director. So that could be somebody outside an organisation who comes in and sits in board meetings, perhaps, who tells people how to run the business and makes decisions, strategic decisions in relation to that company. That doesn't include professional advisors. There's a special carve-out for that because they're providing advice. But anybody else who does that needs also to be aware, and that's particularly a role for consultants.
I also see that in an insolvency situation where a director's been disqualified but wants to continue running a business, and the spouse of the director then takes that sort of position.
Absolutely.
But the disqualified director is still in the background pulling all the strings.
Yeah.
So are there different types of director? So, for example, does a non-executive director have the same responsibilities as a director that would be involved in a day-to-day basis?
Well, yes, they do. Now, the legislation looks very carefully at people and their particular role in relation to the company if they're assessing whether somebody's behaved appropriately and so on. But fundamentally, if you're a director of a company, you're a director of a company and you have all those roles, responsibilities and obligations as well. Clearly, the finance director is more responsible for the finances than perhaps somebody else is. But it doesn't mean to say that anybody can absolve themselves of their responsibilities in relation to the finances by saying, well, that's all dealt with by somebody else. You are respected to understand what is going on. If you're a non-exec director, that means that you are required to have an objective view because you're not actually in the day-to-day running of the company. such as the executive directors are, and being objective in some ways actually gives you some more responsibilities, I think, because you have to have a purview over everything. And I'm a non-executive director myself for a charity, and it is worrying sometimes that you have to take steps to make sure you are in possession of the information you need to be in possession of.
So we've spoken a lot about who might be responsible. What are they responsible for? Where do you find that sort of information out?
Okay, well, first I think it's sensible to think about why there are specific obligations and responsibilities for directors and why it's codified as it is in the legislation and within case law. And that's because limited companies have a particular status, which in general means that they have the privilege that any repayment of liabilities that they incur is restricted within the company. So if you're a sole trader by distinction, then any liabilities from your business will actually sit back with the individual.
And your assets, your personal assets are at risk.
And your personal assets are at risk. Whereas for a director, it's slightly different, and we'll come on to points where that might also be the case. But in generality, directors are protected, and shareholders as well are protected from that. So therefore, directors are required to conduct the business of the company and themselves responsibly. They're looking after fundamentally other people's money, and so that's why there are those responsibilities. And the obligations can be found in the Companies Act, which goes through directors' duties. There are other Companies Act requirements. There are requirements under various other bits of legislation. That's the bit that's very difficult, I think, for directors to actually know what their responsibilities might be, because they might not know that there is legislation in a particular area.
And I guess ignorance is no defence.
Ignorance is no defence, because this is a responsible role. There are also obligations placed upon directors within their own documentation, particularly the articles of the company, but also certainly all companies where you've got directors should have service agreements which talk about particular responsibilities and both sides, so what the company owes to the director, what the director owes to the company. So there are things within that too.
So I think you spoke about it potentially being set out, codified and set out. Is that in the Companies Act?
Well, directors' duties, 2006, the Companies Act from 2006, changed things quite dramatically and actually pulled things together and said there are these 7 duties that directors owe to their company. So to act within their powers, so that's not to do things they're not actually authorised to do, to promote the success of the company, and that might sound a bit weird because you'd sort of assume that they should be promoting the success of the company, but actually the reason it's in there is to make sure that people focus when they're with that company on that company's affairs and not another company's affairs.
Oh, I see. So if there was a group of companies, and you were a director of all of the group of companies, you would have to specifically think about the company that you were looking at that point.
Absolutely. I'm currently advising a large group where they've got common directors across the group in different things, but actually the success of some of the individual companies, the success of the individual companies may be different and be reliant on different criteria to the other companies that they're directors of. So we're having to sit in meetings and effectively take a step back and say, well, which company are we thinking about now, and what's good for this company? So
there can be a real conflict there. I can see that.
It can be a real conflict, and there is one of the other duties says to avoid conflicts of interest. So it's not just cross company, but it's you as an individual. And an example in that might be, for example, if you were director of a building company, perhaps you didn't have shares in it, but you were director of it, and they were applying for planning permission on a piece of land that happened to be near to your personal property. Your interest as an individual might be, I want to oppose the planning, but as a director of the company,
it's the right thing
for the company. Also, the duties talk about exercising independent judgment. So You can amass information from other parties and other places, but you are required to actually pull that together, assimilate it, and then work out independently what the right thing to do is. And I think
so. If you're taking advice from advisors,
yeah,
you're not passing over the responsibility to them. That remains with you.
That's right, and I think that is, to me, one of the most important things about being a director. And if somebody feels that they're not able to exercise independent judgment because they don't have, then they need to question whether they are the right person to be a director of that particular entity. Also, there's a duty to exercise reasonable care, skill and diligence. Now that's an interesting one, because it's here that we start to look at what people's different roles as directors on a board might be. Okay. So the finance director, as we've said, has perhaps slightly more responsibility for the financial side of things.
And presumably if they're a qualified accountant, that would again be a further level of responsibility. And
absolutely, and their conduct will be looked at in the context of they're qualified, and therefore they should be expected to know what's happening in the finances of the company, and to say that they don't is worrying. I mean, I sat in a meeting the other day where there was somebody there who was not a financial person, but he was nonetheless a budget holder for quite a significant amount of money in a particular area of the business. And he sat there and said, well, I don't really understand the numbers myself. I'm responsible for 7 budgets and I don't understand how it all comes together.
Okay.
And that's
and he really needs to get under the skin of that.
Exactly. Because he was reporting to the wider board. And an interesting one that I saw a number of years ago was somebody in an insolvent situation who was facing disqualification as a director, and he was a chartered accountant, and the question from the board, the magistrate, was, well, Mr. So-and-so, you are a chartered accountant, why did you not see this coming? And he just said, well, I was very lucky to pass the exam. Now, that's not actually an adequate defence. And then the other things are all around personal interest and compromising personal interest. So, you're not expected to accept benefits from third parties that would sway your judgment, and again, that links into the Bribery Act. And you are expected to declare interest in proposed or existing transactions or arrangements with the company. So, well-organised board meetings will start the meeting by saying, has anybody got any conflicts of interest in relation to any matters being discussed?
And then I suppose that person would then have the opportunity to step out if that bit was being discussed.
It would be a good chairman of a board meeting will make that assessment, as to what's the appropriate thing to do.
So that's the Companies Act, but you did say that there were other sort of requirements in addition.
That's right. I mean, the Companies Act itself has other requirements on directors beyond the duties. So obvious ones are to ensure the company complies with its obligations to maintain adequate accounting records so that the status of the company at any one time can be ascertained. And I think some people miss that one. And also ensuring the company prepares and files at Companies House its annual financial statements by the due date. And similarly, it meets other filing obligations such as the annual confirmation statement, details of changes in directors and changes in share capital, and so on and so forth. And that is quite serious, and certainly Companies House, as the government's agency in this, is beginning to take this pretty seriously.
What do they do?
Well, I've certainly seen an overseas company that we were in contact with. They were persistent late filers of both their accounts and their annual confirmation statement, and they suddenly got a letter saying to the directors who were overseas, saying you are required to appear in court on X date, which I think was about 6 weeks hence, because you'll be prosecuted criminally for failure to file.
So presumably that could have meant a fine or imprisonment.
Could have meant, it said quite specifically, could have been a fine or imprisonment.
Presumably they got it all in time and didn't need.
It's amazing how quickly they managed to sort themselves out. But I think it's worth being aware of that. The days of just thinking, oh, it's just a fine, we'll just get a fine or just roll over, are now long since gone.
Yeah, and I guess that may be to do with sort of AML type issues where people, government agencies do want to know who's behind companies. And
well, I think it's just this general looking at the responsibility again for managing other people's money.
Yeah, sure.
And then you asked about the requirements under other legislation. So that, again, as I said earlier, there's a whole raft of legislation, which includes health and safety, environmental, data protection, for example, where the director actually has very clear responsibilities. And then there are other sorts of legislation which are governance things. If your company's really large, and it's actually defined as very large in the legislation, which is an interesting concept, over 2,000 employees or turnover of over 200 million, then you need to comply with something called the Waits Corporate Governance Principles. So
won't be too many companies in the UK that applies.
There won't, but equally, I think it's interesting to know because it speaks to this overall increasing professionalism of the administration of companies, which personally I think is a good thing.
Yeah, absolutely. Okay. So you've spoken about the sort of responsibilities and the duties. What happens if you get it wrong? I know from an insolvency perspective what happens if you get it wrong, but on a day-to-day basis, what might happen to you?
Well, there's a raft of things. Certainly you can be held personally liable for a breach of general duties, misleading or false reporting. Certainly we've all seen the press, and if the Serious Fraud Office or the FCA want to mount an action because they feel you've dealt with things inappropriately, then they will do. And certainly I am aware of directors who, as a result of that, have been imprisoned.
Gosh.
So, for example, for fraudulent or false reporting of results, and that would include perhaps inflating your revenue. Typically, those sorts of cases are where it's deemed to be in the public interest, and will typically be where either public monies have been jeopardised, or where if the company is listed because there is more prudence expected and better governance expected. But nonetheless, you can see that happening across a wide range of companies. Breach of Companies Act requirements on corporate administration, as I've already said, can constitute a criminal offence with the penalties as we've talked through. And similarly, negligence in relation to the activities of a company may also be a criminal offence, and that's the one that always surprises people, because here we've got a company which is separate from the shareholders and directors. But if the company does something that's deemed to be negligent, then the directors can personally be liable, and those certainly we've seen prosecutions around corporate manslaughter, and also issues such as company vehicles being untaxed or uninsured. And as we all know, a vehicle needs to have an up-to-date MOT certificate, or a lorry needs to have a current plating certificate, and if they don't have that, then of course they are by definition uninsured, and that can go back to the directors personally. Personal liability. There's a case slightly different to that. There's a case where there was a forklift, a company that had forklift trucks, and the keys were left in the forklift truck, and it managed to start itself and ran somebody over, and the director was held personally responsible for that, because he had apparently said they shouldn't do routine maintenance on the trucks.
And if the maintenance had happened, it wouldn't have been able to.
One would have hoped so. Hope not. Yeah, absolutely. And then other things that can happen are disqualification or undertakings in lieu. So as you know, Sandra, from your involvement in insolvency, grounds for disqualification are very extensive, including persistent breach of company law.
Okay, well that probably neatly brings us on to talking a little bit about the insolvency aspects of it. But just before I do, I would just like to ask our audience a question. In terms of, I think there are something like 17,500 corporate insolvency failures every year, and therefore I estimate there's something like 40,000 directors associated with those failures. I just wonder whether the audience have a view, on average, how many directors each year get disqualified. So is it between 1,000 and 1,500, or is it between 3,000 and 4,500, or is it between 8,500 and 10,000? I think you probably can use your keypads to be able to sort of answer that. I will come back to that in just a minute, just to give you a little bit of time to answer that question. So the consequences of insolvency. There are two tests initially to establish whether an entity is insolvent, and if either of those tests is met, then the entity can be described as insolvent. So the first test is a cash flow test, so can the entity pay its debts when they fall due? And then secondly, there's a balance sheet test. Is the value of the company's assets less than the amount of the liabilities, taking into account contingent and prospective liabilities? And it's quite interesting to note that it's not illegal for directors to continue to trade an insolvent business, but the risks for them are significantly more if they do decide to continue to trade an insolvent business.
So how would a director in that circumstance manage the risk?
Yeah, well, their focus will need to change from that of creating shareholder wealth to protecting the interests of creditors. Understanding the personal risks and how to mitigate them. And then there's a lot about regular review of performance and documentation of decisions. And I guess from a day-to-day basis, you would also say that directors should be documenting things on a regular basis. Even more critical in this sort of twilight zone where you're trying to turn things around. So the good management information is essential. So a turnaround plan, you've got to have that within a feasible timescale. There's no point having a turnaround plan that might last 20 years, because you can't. I suppose very large companies might have that, but most companies can't forecast that far ahead very accurately.
And I guess also you can't be holding up your creditors for that long to actually,
Yeah, absolutely. So based on that, I mean, directors need to consider whether it's advisable to continue trading, and if it is, can they finance that additional trading? And then we were talking about having that good management information. If you can see a deterioration from that, from the information that you're getting, should you still continue to trade, or do you need to take some further action or stop trading, for example?
Yes. Yeah.
And also, you were speaking a lot about other people's monies that they're responsible for. Particularly important here, because if you incur further credit, you know that that's potentially at risk, and therefore you need to be very careful when you take additional credit, that credit is, you feel that is likely to be repaid.
And is there a carve out on that, Sandra, where if you've told the lender or the provider of that additional credit that about the circumstances, that then you're sort of pretty much covered? Yes,
that's right. So yes, but the creditor where you might have just gone and ordered some additional material and stocks and has no idea of your financial state, they would have a much louder voice in terms of if it all went wrong than somebody that obviously knew the circumstances and was prepared on that basis to put money in.
And I guess you see that quite a lot in your role. That, if a company does go into liquidation or something, you have very vocal creditors who feel they've been duped.
Yeah, absolutely. And similarly, there are directors might put their hand in their pocket to put some more money in, and actually, if they then lose that money themselves, they kind of were in full knowledge of the circumstances. And then there's things like customer deposits. So, going back to sort of the early 90s, there was a plethora of sort of world of leather type shops where they'd take customer deposits, and some of those furniture shops were taking those deposits where there was 6 weeks to delivery from Mr. and Mrs. Smith, and they knew that they would be not trading next week, and yet they were still taking those deposits. And you can see that could get you into a lot of hot water. What happens if that turnaround plan fails, I suppose, is the next question to ask. So it's likely that you're going to end up in an informal insolvency procedure. That might be administration, it might be creditors' voluntary liquidation, it might be a compulsory liquidation, or it might be a company voluntary arrangement. And there are obligations on the administrator and the liquidator to investigate the conduct. Interestingly, I think it's interestingly, in a company voluntary arrangement, there's no such investigation. And I think the reason for that is that you're putting a proposal to your creditors which says, here's what's happened to the company, and here are potentially areas where our conduct has fallen short. You have to disclose these things. So therefore, creditors that approve that voluntary arrangement are approving it in the knowledge of what's gone on, and they're prepared to basically support them. Yes, absolutely. So it's only administrators and liquidators that have the duty to investigate, and they investigate any director that's held office in the 3 years prior to the insolvency, and that could include de facto and shadow directors that you were talking about earlier.
Yeah, and I think that's something that people need to be aware of in taking on the role of a director or having the name director on their business card.
Yeah, absolutely. And that report goes to the insolvency service for the insolvency service to consider whether there might be grounds for disqualification against those directors.
Yeah.
And also the administrator or the liquidator is looking to see whether there's grounds for an action to be brought against directors or others for the recovery of monies for the benefit of creditors.
Yeah.
And if there's criminal activities, we have an obligation to report them to the relevant authorities. Now, at the start of when I was talking, I did say to people that are listening, well, how many directors do we think are, on average, are disqualified every year? And it looks like 29% of people thought it was between 1,000 and 1,500. Most people plumped for 3,000 to 4,500 a year, and a few people thought it might be between 8,500 and 10,000. The actual answer is it's between 1,000 and 1,500 every year. So actually, on a pure numbers game, if you've got 45,000 directors on average going through an insolvency procedure every year, the likelihood of getting disqualified is actually quite small. But it does tend to be for things which are public interest related.
And that must be frustrating for you as an insolvency practitioner, where you see people who have conducted themselves very badly, and you actually may not feel they should be allowed out to keep doing that again.
Absolutely.
To get a report back from the insolvency service saying, well, no action being taken.
Absolutely. But I think it probably will come down a lot to funding of the insolvency service to be able to do that, and they will only take the cases where they feel that there is a real public interest in doing so.
So what would the insolvency service actually do? What's their role in all of this?
Okay, so they'll have received the report from the insolvency practitioner, and then they will decide whether it's appropriate to undertake their own investigation. And having undertaken that investigation, they'll decide whether it's appropriate to seek a disqualification, either by agreement or order, as you were speaking about earlier. And disqualification can be between 2 and 15 years. So for the least serious offences, you might get disqualified somewhere between 2 and 5 years. For slightly more serious offence, then it's 6 to 10 years. And for the most serious offences, 10 to 15 years. So it's fairly serious. It will have a fairly large impact on somebody for a number of years potentially.
And what would you say are the key focuses that the insolvency service would focus on in terms of actions that people have taken as grounds for disqualification?
Well, they list a number on their website, which are on the side there. In my experience, they quite often focus on whether there's a large debt due to the Crown.
Oh, that's interesting.
Yeah, and whether I've just been that's been an unusual aspect of my cases, but I think that's probably not. But they also focus on whether the company continued to trade when it couldn't pay its debts, not keeping proper records, which you were talking about earlier, not sending accounts into and returns into Companies House again, which you were talking about earlier, the one which I said at the outset, which was not paying your tax, and using the company money or assets for their own personal benefit. So those are the sort of areas which they consider to be the most serious things that need investigation.
I guess also members of the public, where members of the public are perhaps uninformed, generally are trading with, a company that gets into difficulty. So I guess they're going to look quite critically at that as well. And you mentioned people making deposits for sofas and that sort of thing. The other one that springs to mind are the Christmas hamper companies. People who really couldn't afford to lose the money will lose the money.
And there's been quite a lot recently around gift cards with retailers going into insolvency situations. So those are quite obviously quite high on ministers' agendas as well, because they're in the public eye, so they tend to get that scrutiny.
So what does disqualification actually mean then, Sandra?
Okay, so if you're disqualified as a director, you cannot be a director of a company registered in the UK or an overseas company that has connections with the UK. You can't be involved in the forming, the marketing or the running of a company and in the UK. And breaking the terms of the disqualification, either a disqualification order or agreement, is a criminal offence, and it can lead to a fine or imprisonment for up to 2 years or both. Don't see it very often, but for the most serious cases, that may well be the case.
I guess it can also bring other people on the board into disrepute as well. And I certainly was aware of a case a number of years ago now where the main director was actually disqualified, but had because he was bankrupt, and he had set up this company, taken a lot of people's money into this company, and he had the book thrown at him in court, as you say, under a criminal offence. But also, other directors also had the book thrown at them for allowing him to be involved in this company, and they should have known that he was unable to be a director, and that is another thing to think about. If you're a board director, you have to know your other directors.
Be very careful to know who you're acting with. It's very serious. So you asked about the sort of what implications there might be. Well, they're quite far-reaching. Not only can you not be a director of a company in the UK, but you can't sit on the board of a charity, a school, or police authority. So it could be personally embarrassing if you had to resign your positions from those. You can't be a pension trustee. You can't be registered as a social landlord. You can't sit on a health board or a social care board, and for solicitors, barristers and accountants, you can't practice, so it actually stops your ability to earn a living.
So I think this comes back to my earlier point about people perhaps who, for the greater good, trying to do the right thing, become directors or trustees of charities. And let's say something goes wrong within that charity. It may not be that individual's fault at all, but they run a risk. They could be disqualified as being a director in consequence of what happens to the insolvency of the charity. That could then affect the rest of their lives.
Yeah, absolutely. And we were speaking earlier as well about acting on the instructions of a disqualified director. You can be prosecuted for that and be personally liable for the debts of the company. So, as I was saying, bankrupt with spouse, sort of running the company, watch out, because the whole family's assets are then at jeopardy. So I also spoke about the liquidators and administrators having the ability to recover money for the benefit of creditors. So that's the lifting of the corporate veil and going behind. So there are some grounds that we look at, some areas that we look at when we're appointed liquidator or administrator of a company. So we look at misfeasance and breach of duty, falsification of companies' books and records, and making false representations to creditors. Going back to what you were saying earlier, really. We look at whether a company's been trading wrongfully. So did it continue to trade at a point in time where it knew or ought to have known that it couldn't avoid an insolvent liquidation? And from that point in time, the position got much worse for creditors. You could be asked to bridge the gap. Fraudulent trading, was it set up for a fraudulent purpose? Did it undertake a fraudulent trade? Transactions at an undervalue. So the typical one that we sort of quote there is the builder where, sorry, not the builder necessarily, but a builder, say, with an extension on the back of his house that the company's put on, and he's not paid full market price for it, or it's been gifted to him by the company. That would not be fair. Preferences. This one again, there's some obvious preferences, but there's maybe some less obvious preference. So an obvious preference might be that you pay the supplier of something because you are thinking about setting up another business after this one had failed, and you need that supplier going forward. But there's less obvious preferences where, for example, a director's personally guaranteed an overdraft facility. That overdraft facility had been at, say £500,000 3 months before the insolvency, and it had come down to nothing at the date of insolvency, and that would then wipe out the personal liability for the director under their guarantee, but they preferred themselves as opposed to paying other creditors, trading expense creditors, for example.
So what would you consider before taking action against a director as an insolvency practitioner? Okay, well
there are a number of things that you would look at. Have you got good grounds to be able to take an action? If you're going to succeed, are you going to be able to recover monies? Are you going to be able to fund it? And I would obviously also want to take creditors' views, because quite often, if you are funding it from resources that you have got within the liquidation or the administration that would otherwise be available for distribution to creditors, their views would be, sort of important factor in taking that. And then, I mean, mostly you don't end up actually at the court, but you probably settle some way before. Maybe you have a mediation or there's some engineered settlement. But I think one thing that is really important here for directors is, I've got all these fantastic powers to try to recover money for creditors. The director's probably strongest response to that would be to say, here are the notes that I took at the time. This is the context. This is why I undertook this transaction. And therefore, in that context, that makes perfect sense, because me as a liquidator administrator, I have 20/20 vision in terms of hindsight. But it's very helpful for a director to have kept a contemporaneous sort of note of what it was that they knew at the time, and that's why they took those decisions. So I think we've had a quick canter through this, but I just wonder if you might briefly sum up for the participants in this webinar what it is that we've been saying. Then we'll have a look at any questions that people might have posted.
I think the first thing is to check whether you could be considered to be a director, and the points I raised earlier, you might not realise that you could be considered to be a director, but and therefore what your obligations might be as a result. Understand the obligations and duties of a director. I think that's something that people don't realise. They become a director and they don't necessarily, they sort of think, oh, it's a badge, I'm now a director and I'm important, etc., etc. But actually, there's a lot of legislation that you have to comply with. I would say personally, I've long held that people should sit an exam or something like you do a driving test, take a car out on the road, don't you? You should do something similar.
Yeah, you could be responsible for people's lives. You could be in a company and all sorts of things.
But it's just to make people realise that that they are actually, the things that they are responsible for.
And not be there in ignorance.
And I think take an active part in this. It's not enough just to rock up if you're a non-exec just to a meeting once a quarter. You really do need to understand the guts of what's going on, and take an interest in your fellow directors' actions as well, and perhaps where they're coming from. The example we gave earlier about a disqualified director who shouldn't have been a director, and the implications for fellow. Even if you're not financial, you haven't got a financial head, you need to understand what the finances are saying.
Get someone to explain it to you if you don't understand.
Absolutely, and coming back to my example earlier of the chap at the meeting who's very senior position, didn't understand the numbers he was actually supposed to be responsible for. I think if you get into difficulty or worried about something, take advice. There's plenty of opportunities and places to take advice from, and you should take that advice and act early upon that. Have a plan and monitor performance. So if things are going awry, as you suggested, if you're worried about the solvency or you've got some difficult financial trading position, then you should have a plan, and not just do a plan and then put it in the cupboard, but it's monitoring it very frequently. If you're in a real crisis situation, you should be looking at that and checking whether the basis of your plan has been changing, any assumptions that you've made, and address those accordingly. And discuss and document key decisions, which I think we've both been saying right the way through, but do things contemporaneously, and then you're covered. Okay.
Well, we have a few questions here. We have a question. Sue, you might be able to help out on this one as a trustee of a charity. So it says, can directors of charities have their liability limited in any way?
Fundamentally, no, because you are a director, and that's what goes with the territory. As I said earlier, if there was a problem in relation to the company or charity, and directors were under the microscope as a result of that, then certainly the level of your personal involvement, the level of the actual specific role that you have within the organisation would be considered, but nonetheless you are still responsible, and that comes back to my point. You take on a directorship, you have those obligations as well.
There's also a question here which talks about deciding the side of professional indemnity insurance, which probably brings me on to the point also of directors and officers insurance. There is the ability to sort of try to obtain insurance cover to sort of mitigate some of the risks potentially of falling foul of some of the financial aspects. And I would suggest that you sort of speak to your own broker about that.
And that's quite an interesting one. Certainly I work with lawyers quite a bit, and some of them are sitting on boards of companies, and they say they won't act unless they have professional indemnity insurance. And I think that's a very good rule to have.
And the brokers should be able to advise on any level of
absolutely
insurance that you require.
Yes, they do. And they will look at the circumstances of the company and the sorts of things that you're engaged with. So, for example, I act for a lot of life science companies that are doing drug development, they're going through clinical trials and so on. That's a real potential high liability there, and that's something that we look at and with brokers quite critically.
Well, I think that sort of brings us to the end of the webinar today. Thank you ever so much, everybody, for listening, and I hope you found that useful. I think it will be posted later on our website if anyone wants a recap. Thank you very much.
Thank you.